Mr. Sultan Mahmud, Mr. Shahidul Islam Sardar, Mr. Farooq Ahmed, Mr. Abdullah Al Numan, Mr. Abdul Sattar, Mr. Mamunur Rashid, MD Hassanul Banna, SM Moinul Karim, Mr. Saikul Mahdi, Mr. Tariq Abdullah, Mr. Saimum Raja, Mr. Tasmirul Islam, Mr. Tanvir Hossain Joha. Our thanks to all our staff, whose names I could not mention by this time. Our heartfelt thanks to the learned Attorney General, who have attended the trial at the inception and at the conclusion. Over and above, our thanks from the core of our heart to Mr. Tajul Islam, the learned Chief Prosecutor, for playing the part of excellence. We are thankful to all others. Thank you all. Now let us say something about. I am sorry. I am very much sorry. Our sincere thanks to the learned defense lawyers, particularly the learned State Defense Lawyer, Mr. Amir Hussain. Many people will say many things, but he has done a lot. And he, in our view, in our estimation, to the best of his possibility, he played the exact role he was supposed to, and that we expected. Thanks to him again. And if anyone is left, sorry that we do not by this time recollect. Our thanks to the Learned Attorney General again for his kind presence. We are sorry for being late because many things are connected in the preparation of the judgment. This is a very big matter. For the last couple of days, we could sleep very little, and we had to work continuously for 10 to 12 hours every day. So, anyway, this is our job, but all of you are waiting. You have participated in many ways. Thanks to you all. Now let us discuss something about the judgment. I want to give an idea of the judgment. The judgment comprises 453 pages. And it consists of 6 parts. The first part includes the index, description of the prosecutors, learned prosecutors and the learned defense counsels, introduction of the accused, origin and object of the tribunal, jurisdiction of the tribunal. Article 7 of the Rome Statute, which is the basis of trial of our tribunal. Elements of the crime against humanity. We are trying the offense, we are holding trial of the crime against humanity. So, elements of crime against humanity, these are enunciated by the Rome Statute and being followed and exercised by the International Criminal Court and other international tribunals. We are also following the Rome Statute as well as our law, and particularly the elements as enshrined therein. And the elements of superior command responsibility. In such cases, superior command responsibility is bulkily involved, and that's why we have to have regard to this aspect as well. And we have stated the standard of the tribunal. That is, we compare the standard of this tribunal with the standard of the other international tribunals as well as the International Criminal Court. And we have said about the trial procedure, part 2, pre-trial proceedings, part 3, prosecution story and defense case. We on charge, learned State Defense Council's submission on charge, thereupon decision on charge, and then we have given the description of evidences in part 4. In part 4, we have also given an account of the testimonies of the prosecution witnesses. In part 5, we have given the illustration of the evidences, that is the discussion of the evidences. Used arms and ammunitions. We have given an account of the used arms and ammunitions. We have given a description. We have discussed about the telephonic conversations of accused Sheikh Hasina with a number of persons from time to time. We have discussed and extracted the reports of daily news to the deliberations. Thank you very much. Now, the turn of our learned member to his reading out, as I have mentioned.
Origin and object of the tribunal. The International Crimes Tribunal has been established under the International Crimes Tribunal Act 1973 to provide for the detention, prosecution, and punishment of the persons for genocide, crimes against humanity, war crimes, and other crimes under international law committed within or beyond the territory of Bangladesh, whether before or after commencement of the Act. Jurisdiction of the Tribunal. The Tribunal has got the jurisdiction to try the offences enshrined in Section 3 and 4 of the International Crimes Tribunal Act 1973. Section 3 provides, a tribunal shall have the power to try and punish any individual or group or individuals, organization, or any member of any discipline force, auxiliary force, or intelligence agency who, irrespective of his nationality are British. The Constitution of Bangladesh has given upper hand in Article 47, subarticle 3 thereof to the application of the provisions of International Crimes Tribunals Act 1973 in the following manner. Of any persons who is a member of any armed or defense or auxiliary forces, or any individual group of individuals or organization, or who is a prisoner of war for genocide, crimes against humanity, or war crimes and other crimes and crimes under international law, shall be deemed void or unlawful, or ever to have become void or unlawful on the ground that such law or provisions of any such law is inconsistent with or repugnant to any of the provisions of the constitutions. Crime against humanity, namely murder, extermination, enslavement, deportation, imprisonment, abduction, confinement, torture, rape, sexual exploitation, enforced disappearance, human trafficking, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or other inhuman acts when committed as part of a widespread or systematic attack direct against any civilian population with knowledge of the attack, or persecutions on political, racial, ethnic, or religious grounds, whether or not in violation of the domestic law of the country were perpetrated. Section 4 provides as follows. Any individual or groups of individuals or any member of any discipline force, auxiliary force, or intelligence agency who commits a crime within the jurisdiction of the tribunal shall be responsible and liable for a punishment. Any commander, superior officer, or leader who orders, permits, acquiesces, incites, or participates in the commission of any of the crimes specified in Section 3, or is connected with any plans or activities involving the commission of such crimes, or who fails or omits to discharge his duty to maintain a discipline or to control or supervise the actions of the persons under his command or his subordinates, whereby such persons or subordinates or any of them commit any such crimes, or who fails to take necessary measure to prevent the commission of such crimes. Now, crimes against humanity according to Rome Statute. For the purpose of this statute, crime against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with the knowledge of the attack: A. Murder. I am reading the relevant ones. Murder, torture, other inhuman acts of a similar character intentionally causing great suffering or serious injury to body or to mental or physical health. The core offense in the instant case is the crime against humanity. Thus, we have to see what elements are required to constitute this crime. Section 4 of the Act, there must be an attack. B. The attack must be widespread or systematic. C. The attack must be targeted a civilian population. D. The attack must be within the knowledge of the superior, or the superior should have known of the attack in order to hold him or her liable for the crime. The superior must have been in the control over the concerned subordinates. Elements of superior command responsibility. From the jurisprudence and eminent from the